Hello, Miss Hazwani. We are from Group 4, Bachelor of Business Administrative Islamic Finance. So this is our team members. We will be present about discussion of question for A and B.
I would like to explain the detail on discharge of the contract with reference to decided cases and statutory provision. First of all, we go to the meaning of discharge of the contract. What is discharge of contract? Discharge of contract in commercial law means terminated. It involves a situation whereby the parties to the contract is no longer obliged to perform the contract. In commercial law, the term discharge of contract refers to the termination or fulfillment of contractual obligations, releasing the parties from their duties and obligations under the contract. Discharge of contract can occur in various ways, which is it depending on the circumstances and the terms of the contract. Discharging a contract in commercial law is divided into four methods, which is by performance, by consent or agreement between parties, by impossibility, and the last one is by breach. Here are the examples of cases that explain the discharge of contract. The cases is the plaintiff promised to install heaters in the defendant house. The plaintiff installed the heater, but then the heater was not working. The defendant did not pay the plaintiff. The contract has been discharged on the part of the plaintiff because he is supposed to install work heaters and not broken heaters. Next, we will go to the first method of discharging a contract in commercial law, which is by performance. Discharge a contract by performance means the doing of that which is required by a contract. Discharge by performance takes place when the parties to the contract fulfill their obligations arising under the contract within the time and in the manner prescribed. In this method, both parties have to carry out their obligations. According to Section 38, Subsection 1 of Contract Act 1950, both parties to a contract must be prepared to perform his obligation at the time and place at which he has undertaken to do. It means that the contract must be strictly performed in accordance with the terms of the contract unless the parties have agreed otherwise. According to Section 42, in this method, performance of the contract may be performed by a third party and not necessarily from the promisor. Discharge of a contract by performance can be divided into two. First is actual performance. Actual performance is when both the parties perform their promise. The contract is discharged. Performance should be complete, precise, and according to the terms of the agreement. Most of the contracts are discharged by performance in this manner. Secondly, attempted performance or tender. Tender is not actual performance, but is only an offer to perform the obligation under the contract, where the promisor offers to perform his obligation, but the promisee refuses to accept the performance. Tender is equivalent to actual performance. Next, I will pass to the next presenter that will explain other three methods of discharging of the contract in commercial law.
The second method of discharging a contract is by consent. This contract exists or was created by consent since both parties agreed and gave permission to terminate their contract. It is imperative to reach agreement in this method in order to prevent problems in the future. Section 63 says that if the contracting parties agree to substitute a new contract, replace the contract, cancel or change it, the original contract will be erased as if it did not exist. Plus, Section 64 states that if the person is satisfied with the contract, even if it is small, the contract will be bound. It does not matter whether the payment is in a small sum instead of larger, that can make the other party satisfied then the contract is binding. For the next method, it is discharged by impossibility of performance or frustration. In this method, any agreement that is impossible or unreasonable to implement is legally void. There are two situations in which a contract is unenforceable. First, according to section 57 subsection 1, a contract that is impossible to perform at the time the contract is made. For example, Party A agrees with Party B to search for magic treasure, so according to this section, this contract will continue to be cancelled. Second, the act becomes impossible or invalid because it cannot be prevented, causing the contract to be void. In the event of an impossibility of performance, the contract will be frustrated. There are 5 contracts that can be frustrating. Firstly, the destruction of the subject matter of the contract, such as the music hall hired by the defendant was burned down before the time of contract. Second, the supervening event defeats the whole purpose of the object of the contract, like the case between Krell versus Henry. Due to the frustration of the contractor, the defendant is excused from paying rent for the room. Third, the supervening illegality of a contract affected by it means that the contract can change from legal to illegal. Fourth, frustration can occur when death or permanent incapacity. This contract then will discharge. Lastly, all of the contract with the enemy will be frustrated because of the declaration of war. Last but not least, discharge by breach is one of the methods in discharge of contract. Under section 40, when a person fails to perform a contract, the non-breaching party has the right not to continue with the contract and seek damages. Like in the case between Chow Yin Lo versus Visuvalingam Pillai, the court stated that it was a breach of contract because the plaintiff did not follow the contract, which provided a small number of workers compared to what should have been in the contract. After that, there are remedies for contract breaches. Start with damages, meaning compensation in the form of money or value. The number of damages that can be recovered is specified in section 74 of the Contract Act or by the decision of Alderson B. in Hadley versus Bezodel in common law. Next, to claim special damages, the other party must know that special damages may be caused by the breach when they enter into the contract. According to section 75, the plaintiff cannot recover an amount in excess of what is subject to the contract if the amount is stated in the breach of contract. Second, for specific performance, it will be given when the court forces the defaulting party to perform their contract and the remedy is given at the discretion of the court. In the section 21, subsection 1, clause 2, SRA, which is Solicitor's Regulation Authority, specific performance will be given when the damages are insufficient damages. The court will order the person who fails to perform the contract to perform it. The SRA then makes provision in section 21, subsection 2 for circumstances where the court cannot order specific performance, such as when doing so will give the defendant an unfair advantage. Other than that, injunction in preventing someone from doing something or ordering them to carry out a specified action according to the court's discretion. Next, quantum merit means that the person who injured may be eligible to make a claim for the work and services they provided in an amount equal to what he had previously earned. Finally, rescission took place when the contract was voided as a result of its voidable nature.
Next, for the answer of question 4b, based on Jamila's situation, we know that Jamila relied on the seller's skill and judgment before purchasing the goods, which is the facial cleanser. After the seller, Michael, who is also known as qualified pharmacist, recommended her the facial cleanser with the brand name Ola. After using the facial cleanser, her skin started to have rashes, inflammation, and also itchiness. The issue is whether Jamila can claim her rights against Michael.
As a general rule, when an individual acquires goods, for example, a buyer, they typically obtain the same right to those goods as the person from whom they acquired them from. For example, a seller. sales of goods at 1957 will be more likely to apply in this situation. Section 4, bracket 1 of sales of goods at 1957 defines a sale of goods contract as an agreement in which the seller either transfer or agrees to transfer the property of goods to the buyer in exchange for a specified price. It is possible to have a sale contract between the part owner as well. According to Section 5, bracket 2 of sales of goods at 1957, the sale of goods is subject to the applicable laws and parts. Sales contract can be formed through written agreements, verbal agreements, or a combination of written and oral communication. Additionally, contracts may also be implied from the conduct of parties involved. This means any method can be used to form a sales contract, either in terms of communication, writing, or merging between two, even implicit behavior between the parties involved. Sales of Goods Act provides some implied terms. Under implied condition as to quality of fitness, the general rules state that the principle of caveat emptor, also known as the let the buyer beware, places the responsibility on the buyer to exercise caution and diligence when making purchases. If the buyer fails to exercise care, they must accept the consequences of their decision. In such cases, the seller cannot be held liable if the goods do not meet the expected quality or fail to possess the desired attributes as required by the buyer, unless it establishes an implied condition that the goods must reasonably suit the specific purpose intended by the buyer. In the event that the goods fail to meet the buyer's intended purpose, the seller can be held responsible for breaching this condition, allowing the buyer to seek damages or cancel the contract. In order to achieve that, there are 4 conditions that must be satisfied. Which one of them will apply in this case? Section 16, bracket 1, bracket 8 of Sales of Goods Act 1957, the reliance on the seller's skill and judgment means that if the buyer relies on the expertise and judgment of the seller when purchasing goods for a specific purpose, the seller is obligated to use their skill and judgment to select or provide goods that are suitable for those requirements. If the requirements are not fulfilled, the buyer could potentially claim for damages or rescind the contract. A similar case, Camelite and Company versus Manganese, Bronze and Brass Co. Limited, 1934. The buyer contracted the seller to build ship propellers according to a specified design. The propellers were meant to be suitable for a particular ship and its engine, with some details such as propeller thickness left to the seller's skill and judgment. However, when the propellers were manufactured, they did not work well or efficiently on the ship's engine due to improper fitness. Camelite and Company sued Manganese, Bronze and Brass Co. Limited, agreeing that the propellers were not fit for their intended purpose. The buyer claimed that they had informed the seller of the purpose and relied on their expertise to provide a suitable product. The court ruled in favor of the buyer, holding the seller responsible for breaching the implied terms. The court found that when a buyer relies on the seller's skills and judgment, there is an implied term that the goods provided will be reasonably fit for their intended purpose. Although the propellers meet the specified design, they did not fit the ship's engine, which was essential for their intended purpose. Therefore, the seller was held liable for breaching the implied terms. Next, we move on to the application of Jamilah case based on these laws.
Under the Sales of Goods Act 1957, the law applied in the Jamilah case when she relied on the Michael's skills and judgment as a qualified pharmacy when purchasing the Hola facial cleanser for treating her skin problem.
From the issue, Section 19(1)(a) of the SOGA 1957 may apply. If the Hola facial cleanser recommended by the Michael does not fully Jamilah's required purpose and causes abrasions, inflammations, and itchiness, Jamilah may have a valid claim for breaching the implied condition as to quality or fitness. She potentially seek a damage or cancel the contract. Next, the case of Kemet Lead and Company v Manganese Bronze and Brands Company Limited, 1934. The law applies from the case if Jamilah can establish that she relied on the Michael's expertise and judgment when purchasing the facial cleanser for her skin problem, and the cleanser failed to fulfill the requirement proposed, causing rashes, inflammations, and itchiness. She may have a reason to hold a Michael responsible for breaching the implied condition as to quality or fitness. So, Jamilah can use this relevant case to support her claim, even though it is advisable for Jamilah to provide evidence such as a receipt, record of conversation with the Michaels, the photo of before and after use of a facial cleanser, and any medical documentation of a skin condition after using the cleanser. The conclusion from this case, Jamilah has a right against a Michael, because Michael was liable for breach of implied condition, which is Jamilah said after she used the cleanser, her skin started to have rashes, inflammations, and itchiness.